Yeah. So we are continuing the discussion of capital maintenance doctrine, and all that we have done is to quickly recap what we did at our last class. So our last class, we continue with specifics of that particular doctrine, and we look at two aspects and the various exceptions which are permitted. So we look at first, the prohibition relating to alteration of the number of shares and also reduction or alteration of liability in respect of the shares. So we look at a few instances in which the company may do certain things and to be considered as not undermining the capital maintenance doctrine. So in the case of, let's say, alteration of the number of shares, for example, we realize that the company can pass the necessary resolutions and increase the number of the authorized shares or the registered shares where there's a need for more shares to be issued, and the company has exhausted the number of registered shares. So we talk about that. And then again, we also came to talk about the fact that where the numbers of the shares are too clumsy or too many, the company may decide to do what you call the consolidation exercise. And we tried to draw analogy with redenomination yesterday, and we use the figures to illustrate it. So the consolidation is simply the company having what we call the exchange ratio, so that you try to reduce the number of shares and say that for each stated huge number of shares is going to count for a particular fewer or just a one number of shares, as it were. We'll look at it. And then again, tonight, then we also move on to discuss the rule on financial assistance. We look at the general rule that a company should not give financial assistance. And then we look at some instances in which the company is permitted to give financial assistance, and it will still not be treated as breaching capital maintenance rule, because when those instances are carefully scrutinized, carefully examined, you will notice that the company is ultimately benefiting from such situations, and it will even go to strengthen or enhance the capital position of the company. So, for example, we look at where the company is paying brokers to help the company to get subscribers. So long as the company is paying more than 10% of the value of the shares being issued, then that is permitted by law. Or where the company decide to let shareholders feel motivated and say that it's going to make a certain amount of money available to shareholders so that they can acquire shares in the company. Or is going to, where is in the business of giving loans, and somebody takes a loan and a person decides to use a loan to buy shares, that is not considered as a company providing financial assistance. Yes. Then we also look at the situation of dividends, where you are an existing shareholder, dividends is declared, you get your share of it. And instead of using the money, you decide to use it to buy more shares. That is also not considered as the company giving you financial assistance. So these were some of the things that we discussed yesterday. And tonight, we want to look at another big aspect of the exceptions to the prohibitions we saw in section 58 of the capital maintenance doctrine. So tonight, we are talking about acquisition by a company of its own shares. So as we saw in section 58, as a general rule, a company is prohibited from acquiring its own shares. Why? The simple reason is that when shares are issued, company gets money back from the issue of shares. So if the company is going to acquire shares, what it means is that the company is going to return the money to the shareholders and take back its shares. And that is really counterproductive in terms of capitalizing the company. And that is the rationale. That notwithstanding, Section 61 permits certain things will be done, which on the face of it may appear to us to be the company acquiring its own shares. And yet, if you go beyond the surface and get to the deep, you will notice that it is an exception to what the law is prohibiting under Section 58. So we look at the instances. So the first instance is Section 61(1)(a), where the company is permitted to create redeemable preference shares. And we have explained redeemable preference shares simply to mean that shares which are issued by the company on the understanding or on the terms that the shares will be taken back by the company and money returned to the shareholder at some point in future. Now, so long as the company is following the strict procedures or parameters prescribed in the law, as we'll be seeing in Section 62 to 65, that is really permitted and is not a breach of the capital maintenance doctrine of Section 58. Point 2, if you look at Section 61, subsection 1B, the company is also permitted to purchase its own shares. And what is that? What they call the share repurchase. And we're making the point that on the face of it, if we say share repurchase and then the redeemable shares, it may sound as being the same. In reality, it's not. There's a bit of a difference. And the difference is this. In the case of redeemable preference shares, from the moment the shares are issued, the parties know that the share will be acquired back by the company at the future date, at this price, or on these terms, and so on and so forth. The parties know ahead of time. So that is the 61(1)(a). However, with respect to 61(1)(b), that is a repurchase. It is something which occurs later, and it will be an agreement, if you like, between the company and the particular person whose shares is going to be repurchased, as it were. Yeah, so that is what happens. And in that case, the terms will be negotiated later, unlike redeemable preference share, where the parties already know how much is going to be paid back to the shareholder when the company decides to acquire the shares. So these are some of the things. And then the third scenario is where there's a voluntary transfer of shares to the company. And by that, we mean that someone who is a shareholder can say that, well, I'm no longer interested in being part of this company. So I want to surrender my shares to the company so that I leave the company and I move on. So that is a voluntary transfer by the shareholder to the company. And nothing prevents the company from actually accepting such surrender by the shareholder. So that one is also permitted. Then again, we have the fourth scenario, what you call like the 61(1)(d), compulsory purchase, or what you call like the buyout. And that applies where the court is dealing with oppression. So there's what they call remedy against oppression. So where you have a minority shareholder who has been complaining that the way and manner the affairs of the company are being run are actually detrimental or in disregard of his proper interests as a shareholder and all that. At some point, the court can even, commission inspectors, or the registrar of companies can commission inspectors to go into the company and look at the realities on the ground and all that. Now, where the court is of the view that the only way to resolve the controversy and let peace prevail is for this shareholder to actually be bought out, then that will be done. So what it means is that the court will cause valuation to be done for us to know how much that particular shareholder's share is worth. And then the company will have to buy those shares as a result of an order which the court will have made against the company. So that is something we'll be encountering later on when we are discussing section 222, what do you call it, the remedy against oppression and all that. Good. Now, let's have this at the back of our mind. Then we move on to section 61, subsection 2, which clarifies that shares shall not be redeemed, purchased, or acquired by the company, so long as there is an unpaid liability on those shares. So the general rule for all the things we have observed under 61 is that whether you are talking about redemption of redeemable preference shares, we are talking about the company acquiring back shares through repurchase or through voluntary transfer, or even through buyout provisions as in sections 222, there must be no debt on the shares. So there should be no unpaid liability. That is to say that shares which can be redeemed, shares which can be acquired back by the company, must be fully paid up shares. There should be no amount remaining unpaid. So let us keep that in mind. And that is very important, because if that were not the case, then the company would definitely be losing out, and it will be sinning seriously against the capital maintenance rule. Because just look at it, shares are issued to bring money. And here is the case, the shares which were issued, the person has not even finished paying. And yet you go out of your way and you take some other monies in the company to pay that shareholder and get the shares back. It doesn't make sense. And that is why section 61(2) is saying that as whether you are going to redeem redeemable preference shares, or the company is going to purchase shares, that's the repurchase, or the company is going to voluntarily accept transfer of shares and so on, there must be no debt on the shares. So let's keep that in mind. Now, I have locked you, so if you want to raise a question, you can always raise up your hand, and then I'll allow you to speak. Now, another important point, which we also notice in 61(3), is that a company may forfeit the shares issued with an unpaid liability for non-payment of the sums of money due and payable on those shares. So that is the right of forfeiture. The company can exercise the right of forfeiture in respect of shares which have not been fully paid. And so what is the forfeiture? Forfeiture simply means what? Cancellation. It simply means cancellation. The company can actually cancel shares which have not fully been paid for. So that is section 61(3). And don't forget that when shares are actually issued, it is a contract between the shareholder and the company. So you have times under which the shares are supposed to be paid, especially if you are not paying outright. Then in that case, when a call is made on you, so a call simply means that a demand notice is served on you by the company to come and pay the unpaid value in respect of your share. And where you ignore it, then the company may exercise the right of forfeiture. That is the right to cancel the shares which have been issued to you. And when the shares are cancelled, are forfeited, what it means is that you are no longer a shareholder. And of course, the company may not even have to refund the amount you paid back to you because you have breached the agreement, as it were. Now, 61 subsection 4 is also giving another important rule that on redemption, purchase, acquisition, or forfeiture, shares shall be available for reissue by the company unless a company, by amendment of the constitution of the company, cancels those shares. So when shares have been redeemed, that is, they were once issued, and then the company has obtained the shares back, or any of the modes of acquiring the shares, repurchase, or in the shares being forfeited and all that, they come back to the company. So ordinarily speaking, those shares are available to be reissued. And if the constitution of the company, for example, is not amended to say that shares which have been redeemed or which have been acquired back are to be cancelled, then they are available to be reissued, to be given to new shareholders or other shareholders. Now, not until they have been cancelled, like not until they have been cancelled or not until they have been reissued. That is given by giving to some other shareholders. We call them treasury shares. So 61.5 introduced the concept of treasury shares. So treasury shares are shares which were previously issued, they've been redeemed, or they've been acquired back by the company, and according to the company's constitution, either they have to be cancelled at some point or they are not cancelled. So until something has happened to them in terms of those shares being given to new shareholders, what we call the reissue, or those shares are actually cancelled so that they no longer form part of the population of shares which the company has, they will be treated as what we call treasury shares. So there are certain terminologies which you have to keep in mind. One is treasury shares. When we say treasury shares, you have to remember what you are talking about, and we are talking in terms of section 61, subsection 4 and 5 read together. So 61.5 tells the shares which are cancelled by virtue of the constitution of the company shall, until reissued or cancelled, be referred to as treasury shares. And we are not talking about shares which have never been issued. No. So treasury shares presupposes that those shares were once given out, but for some other reasons, they have come back to the company and they are in the storeroom, if you like, and that is what we call like the treasury shares, waiting to be cancelled or waiting to be reissued. So let's keep that in mind. So let's look at 61 subsection 6. It's giving us more rules on how you can do some of the things that are provided with respect to acquisition by the company, and the company will not be accused of having violated the capital maintenance doctrine. So 61 says that except as provided in section 69, a redemption, purchase, an acquisition, or a forfeiture by the company of the shares of the company, or the cancellation of shares so redeemed, purchased, acquired, or forfeited, shall not reduce the stated capital of the company. Good. This is very important. Stated capital, as we will come to discuss very soon, refer to simply the amount of money the company has raised from the shares that it has issued. That is a basic meaning. So the company has issued shares. The company gets money for the shares that it has issued. So when the monies are put together, both the cash and also the other non-cash equivalent, when everything is aggregated, what you have is what we call the stated capital of the company. So money is actually paid for shares issued. That is a stated capital, to put it very simple. Now, we are being told that where there has been redemption of, let's say, redeemable preference share, or there has been maybe repurchase by the company, or some other forms of acquisition, including forfeiture of the shares by the company, that per se should not be treated as reducing the stated capital of the company. That is a general rule. Of course, section 69, if you later go and discuss section 69, you will notice that there are rules on what they call reduction of stated capital. So for stated capital to reduce, there are a number of things which need to be hidden. But we'll come back to 69. So let's go back to our section 62 and continue with our discussion. But maybe just before we come to section 62, to look at the details of what is entailed as far as redemption of redeemable preference share is concerned, let us briefly discuss section 61.7, which states, voting rights shall not be exercised, and dividends shall not be payable on treasury shares, and except where otherwise stated, treasury shares shall not be treated as issued shares within the meaning of this act. Yeah, so that is very important. Now we know what treasury shares are. Not too long ago, under section 61.5, we're told that treasury shares are shares which have been redeemed, which have been forfeited, or which have been acquired back by the company, and they are waiting to be reissued or waiting to be cancelled. So those are the treasury shares, and we are being told that unlike the general position where we say that shares attract dividends, right? Shares attract dividends when profits are made and shares are issued. The shareholder will get dividends. Now, with respect to treasury shares, they don't attract dividends. So when profit is declared and you want to determine how much dividend is being earned per share, we will discount or we will disregard the treasury shares. So let us keep that in mind. And again, if you want to take a census of how many shares have been issued by the company at every point in time, we will not count treasury shares. Treasury shares, as a general rule, will be discounted in trying to know the total number of issued shares. So let us keep that in mind. Now let's look at the specific rules on how to redeem redeemable preference share. So the rules of redemption. And section 62 is very instructive. And there are certain rules of thumb or general rules which are provided. So section 62.1 says that despite a provision in the constitution of the company, to the contrary, a company shall not redeem any of its redeemable preference shares except. So we are being told that if your company does not have a tailor-made constitution in which the company has made its own specific rules concerning when and how redeemable preference shares should be redeemed, then the principles we have in section 62, subsection 1, are considered as default rules and will have to be observed. So first, that you cannot redeem redeemable preference share unless you have money in the share deals account. So you use what you call the credit, money out of the credit balance on the share deals account, or monies which have been transferred from, let's say, retained earnings. We are going to explain all of them, so don't worry. Or monies from the proceeds of a fresh issue of shares made for the purpose of the redemption, not more than 12 months before the date of redemption. Let me break down these supposedly big technical rules. 62, section 62 of Act 992 is simply telling us that redemption of redeemable shares involve money. Where is the company going to get the money from? So the company is being disciplined in terms of how to get money to redeem the redeemable preference share. Because redemption simply means that you are giving money to the shareholders and then you are taking their shares. So where are you getting the money to fund that arrangement? And that is why 62 is giving us the permitted ways of funding the redemption. And one of the permitted funds for the redemption is monies from share deals account. And when we say share deals account, what do we mean? Share deals account, as we will come to look at it again as section 65, simply means that when the company is issuing shares, the company is supposed to set up an account known as the share deals account. And when shares are issued and monies are paid in return for the issues, they are supposed to be credited. They are supposed to be entered in the share deals account as a credit. So that is the purpose of the share deals account. So if you have money sitting in the share deals account, you can take that money to fund the redemption of the redeemable preference share. Or, apart from having money in the share deals account, you can also have money transferred to the share deals account for the purpose of redemption. So where are you transferring the money from? There is something you call retained earnings. Later on, we'll be talking about to call it the surplus, right? The surplus of the company. So the surplus of the company basically is what we call the profit, because except that profit is, if you like, an accounting or economic term, because as to how you determine profit is subjective. It depends upon the cost. The accountant amongst you will know this. It depends upon your cost or expenditure component, because if in our basic arithmetic we know profit to be excess of revenue or income over expenditure, then as to whether you'll be able to say that you have profit or not, it depends very much on what is counting as part of the expenditure. And that is why I'm saying that that one is highly subjective. So to avoid that, we are interested in the concept of surplus, right? The concept of surplus. And by the surplus, we are talking about how you have made so much money in excess of the stated capital. So the stated capital refers to the money that you have received from the shares that you've actually given out. That is stated capital. Now, where the company has done so well, and you look at the earnings or the revenue of the company, and if you take the stated capital out and you still have some left, so that is the surplus which we are talking about. So for purposes of redemption, you can transfer, of course, we talk about the surplus. Then what about the retained earnings? The retained earnings, we are talking about where you have discounted appreciation, right? Appreciation in the underlying assets of the company, so that like the rare value addition. So that is the retained earnings, and you can use money from the retained earnings to transfer it from the retained earnings to the shared use account, so that you have money available to finance the redemption of the redeemable preference share. Or you can also have what we call the due conscious issue of shares. So fresh issue of shares. You have unissued shares, okay? You are going to issue them. You get money. And then the money that you get, use that money to redeem redeemable preference share. So the net effect will probably be the same. Some shareholders have been, you are bidding farewell to some shareholders. That is those that you are redeeming. And before you could do that, you needed money. So you also have to go and bring people from outside. If you have an issue share, do issue to them. Then the money that you get, use that money to actually to fund the redemption. So that is the scenario contemplated by Section 62 1B. So let us keep that in mind. So Section 62 subsection 2, where redeemable preference shares have become redeemable and the funds of the company are sufficient to entitle the company to redeem the whole of the shares due for redemption, the holder of those shares may serve notice on the company requiring it to effect the redemption. So as we have indicated, redeemable preference shares are actually contractual, right? At the time that they are issued, the terms are spelled out. When the right of redemption can be exercised by the holder, and when it can be exercised by the company, depending upon the position of the company in terms of money and all that. So where the signals are right, according to the terms of the issue, the holder of the redeemable preference share will just have to serve notice that, please, it's time for me to give your shares back to you and for you to give my money to me. So do the needful. So that is what Section 62.2 is talking about. And 62.3, where the company first redeemed the shares within 28 days of service of the notice, the shareholder who has served the notice may apply to the court on behalf of that shareholder and the other shareholders whose shares are due for redemption, and the court, if satisfied that the conditions of this subsection are fulfilled, may order the company to redeem the shares and may require the company and an officer of the company who is in default to bear the cost of or incidental to the application. Yeah, so we have seen that the right of redemption has to be exercised. You exercise it by serving notice. You serve notice, 28 days have elapsed. The company has ignored you. Then 62.3 is saying that you can go to court and tell the court that you have served notice on the company to redeem your redeemable preference shares, and yet you are ignored. The court will intervene. When the court is persuaded that you have maintainable case, your claim will be upheld, and the expenses involved in such litigation will be visited upon an officer in the company who superintended over such a neglect by the company when a redeemable preference has actually served notice and that notice is ignored by the company. That person will be made to bear the necessary cost. And of course, there is another point we also encountered, sub silentio, or just on the quiet, what we call representative action, right? Representative action. And that is why Section 62, subsection 4 is saying that section 205 is applicable to the scenario we are talking about. And if you go to section 205, section 205 speaks of what we call representative action. Representative action is not new concept. If you remember, when we're discussing the legal effect of registration of the constitution of the company, if you remember last semester, that is effect of the company when registered. We talk about the fact that where a person wants to enforce, and among other things, we said the constitution of the company, when registered, is actually a contract under seal between the company and between each member. If you remember that, we made that point, and we also made the point that where you are aggrieved that the constitution has not been complied with and you want to sue, you have to sue in representative capacity. So representative capacity simply means that when you mount the case in court, despite the fact that you took the matter, the outcome of the case will not inure only to your personal benefit. It may inure to benefit of other people who have got a similar complaint as you. So let's say that there may be other redeemable preference shareholders, right? And they have all served notices on the company that the company should redeem. 28 days have elapsed. The company seems to have ignored them. Now you are Champion Atta. You want to take up the matter, which is good. But section 62, subsection 4 is saying that when you, Champion Atta, should take up the matter, know that you are not going to enjoy any positive outcome of it alone. And whatever good thing which come out of it, it will be enjoyed by all those who were in the similar situation as you. Those who were also redeemable preference shareholders are served notice, and then their notice have not been complied with. All of them will benefit from it. So sue in representative capacity. So it is prudent, it is wise for you to try and build some kind of cooperation among such similarly aggrieved individuals so that you'll be able to pull their resources together and probably hire one lawyer and share the costs. Because if you decide to go solo, and if you are successful, the other people will still benefit and they will not have actually contributed towards the expenses or the troubles involved. So let's be guided by that. Right. We are moving on from redemption of redeemable preferential under section 62 to purchase by a company of its own shares under section 63. Purchase of own shares. So as we have noted that it is permissible under appropriate circumstance for the company to purchase its own shares. And that is what section 63 is speaking to, and it says, and I quote, despite a provision of the constitution of the company, to the contrary, a company shall not purchase any of the shares of the company, except where A, the shares are only purchased out of a credit balance on the share deals account, referred to in section 65, or out of transfers to the account in the manner referred to in that section from retained earnings. B, redeemable preference shares shall not purchase at the price, where redeemable preference shares are not purchased at the price greater than the lowest price at which they are then redeemable, or be redeemable at the next date at which they are due, or liable to be redeemed. So we are being told another thing that, yes, you can purchase shares which the company have issued. We are being told how you should raise money to do that. So we've discussed the first part not too long ago. Now, where the shares you intend to purchase are redeemable preference share, then there's a warning to the company that makes sure that you don't pay more than the amount of money which the company will have paid if the company had actually waited for the agreed time for redemption. Being redeemable preference share, there's an agreed time for redemption. Now, when it's going to be redeemed, it will definitely have to redeem at a particular price. So where the company is going to purchase redeemable preference share, which will have redeemed anyway at a later date, then section 63B is saying that the company should make sure that it's not paying more money than it will pay if it waited for the actual time for redemption. 63C, where the purchase is not made in breach of 64. And what does 64 says? 64 addresses the limit on the number of shares acquired. The company is not permitted to be acquiring all its shares. Then there'll be no shareholder. And then the company will actually lose its character as a company limited by shares. And that is why section 64 says that, quote, a transaction shall not be entered into by or on behalf of a company by which the total number of its shares or of its shares of any one class held by persons other than the company or its nominees become less than 85% of the total number of shares or shares of that class which have been issued. Yeah, so we are being told that if the company deems it necessary to purchase its shares, it should make sure that after the purchase, it will not occur that the number of shares which are actually out there is less than 85% as it were. So the total number of shares which the company has issued out should not fall below 85% after the redemption. So meaning that arithmetically, the company cannot purchase issue shares back more than 15%? Yes. Because 85, yeah, 15%. The company cannot buy more than 15% if you like. Otherwise, that will be breaching section 64. And that is why section 63 C said that a company shall not purchase any of the shares of the company except where the purchase is not made in breach of section 64. And 64 is saying that when the shares have been purchased by the company, right, what will be left with shareholders when put together in terms of percentage should not be less than 85%. So put differently, the company should not acquire more than 15% of the issued shares back. And when we are counting, we are trying to arrive at 85%, according to section 64(2), we disregard redeemable preference shares. And for good reason. Redeemable preference shares, right from the moment of their creation, are intended to have, if you like, a short life span, in the sense that at a future date, they will be redeemed, they will be acquired back by the company, and a farewell made to the shareholders. And that is why, in trying to find out as whether the percentage of issued shares remaining after the company has purchased the shares back will not be less than 85%. We don't count redeemable preference shares because they are, if you like, temporary. They will go at some point. The 64.3, where after shares of a class have been issued and the number of those shares have been reduced, subsection 1 shall apply as if the number originally issued, including shares of the class cancelled before the reduction took place, have been numbered as so reduced. So we are looking at the other scenario where there has been some resolution or some measures by the company to reduce, let's say, the number of the total shares or the number of a particular class of shares. Then question may arise as whether we should use the original total number or we should use the number after the reduction. And that is what section 64.3 is telling us, that we will use the original number in trying to do the computation as whether the remaining number of issued shares is not less than 85%, as we have discussed not too long ago. Share deals account, we've said a lot about it when we started discussion of redemption of redeemable preference shares. So what is it? We've explained it already, but let us consolidate our understanding of it by looking at section 65 of Act 992. It says, and I quote, when a company first redeems or purchases any of its shares, otherwise than on the redemption of redeemable preference shares, out of the proceeds of a fresh issues of shares in accordance with paragraph B of subsection 1 of section 62, it shall open a share deals account and shall credit to that account a sum of money not less than the amount of money to be expended on the redemption or purchase by transferring that sum from the retained earnings as defined in section 1. Yeah, so we are being told that the company, when it decides to redeem preference share or purchase any of its shares, it must have money which is sitting in an account called the share deals account, and that money will be used for the purchase. And don't forget, when we're discussing the redemption, we said that the company can even issue some of it on issue shares, so long as the redemption of the redeemable preference shares is going to take place within 12 months. If it's not going to go beyond 12 months, then it is permitted, if the company desperately needs money, to issue some of it on issue shares and raise money. So when the shares are issued and monies are made, that will be credited to the share deals account. And as and when the company uses money to pay for redemption of the redeemable preference shares, there will be necessary debits against the share deals account, because monies are taken to pay for the redemption, so it will reduce what is in the share deals account. Just as when consciously there's a fresh issue of unissued shares with the view that within 12 months there's going to be redemption, the monies made are credited to the share deals account. When the redemption is only taking place, monies are taken, and so that will be like a debit. Subsection 3, the net price or value of consideration received by the company on the reissue of any of the treasury shares of the company shall be credited to the share deals account. If you remember, not too long ago, we talked about the treasury shares. We said that treasury shares are shares which were previously issued and have been redeemed or have been acquired back by the company by forfeiture or voluntary transfer, as it were. And those shares have not been issued yet, and they've also not been cancelled yet. So they are called the treasury shares. Now, where the company decide to reissue those shares, that is to give those shares to willing shareholders, right? If the company is able to give them at a price higher than the original price at which they were issued before the redemption or forfeiture and they become the treasury shares, then what it means is that the company will have made gain. So that gain, that is the net balance, will have to be credited to the shareholders account. So that is what the subsection 3 is talking about. I know a number of students at this stage will get unnecessarily worried that they are not accounting students. So why do we worry them with this? But the most important thing is the basic concept that we have learned. In terms of the detailed accounting, those who are doing company accounts and all that, they will know how to treat the various transactions. So you will not worry your heads so much about the details of the accounting bit. Now, if you look at the Securities and then the Industry Act, the law which governs Securities Exchange Commission and then the various mutual funds and all that. That is what section 66 of Act 992 is speaking to that. Any of the things that we'll be discussing regarding redemption of redeemable preference shares, buying back of shares, acquisition of shares, which we'll be discussing, as well as the share deals accounts. All these took place from section 61 to 65. Now, section 66 is saying that the provisions that we'll be discussing may be waived or modified by order of the registrar in relation to a company which is for the time being an authorized mutual fund. So mutual fund companies enjoy some exemption if they request, so that some of the things that we'll be discussing will not apply strictly to them. But they must be given the exemption first. So there must be a request, and then the registry of companies will grant the exemption as it were. Now let's talk about acquisition of shares of a holding company. 67. Despite section 58, a company which is a subsidiary may acquire shares in its holding company, where the subsidiary company is concerned as a personal representative or trustee, unless the holding company or subsidiary of the holding company is a beneficiary interested otherwise than by way of security for purposes of a transaction entered into by the holding company or subsidiary of the holding company in the ordinary course of business, which includes the lending of money. Okay, so we're talking about the group phenomenon concept: parent company, holding company, and subsidiary company. And question arises: yes, can a subsidiary company, for example, acquire shares of its holding company, or vice versa? Or can even like a holding company acquire shares in its subsidiary? Of course, that one is too obvious, because that is how usually the holding and then the subsidiary being come about. The mother company or the parent company would definitely be some that having shares in the subsidiary. But the question is the reverse also true? And section 67 is telling us that yes, it is possible for a subsidiary company to actually acquire shares in the holding company. And that remains true even where you are dealing with companies whose ordinary business is the lending of money. And this thing we are talking about, you don't actually get the picture well until you get into thick of finance, right? You're doing arrangements like securitization and some of these very complex funding arrangements where you get a number of the companies coming together to play different roles with the purpose of enabling a certain huge facility to be raised and security arrangements made. That is what section 67 is contemplating. So let us keep that in mind. Then 67.2, a subsidiary which is a holder of shares of its holding company or subsidiary which acquired shares in its holding company before it became a subsidiary of that holding company may continue to hold those shares, but subject to subsection 1, shall not have a right to vote at the meetings of the holding company, or a class of shareholders of the holding company, and shall not acquire any future shares in the holding company, except on a capitalization issue in accordance with subsection 1 of section 77. So the separate legal personality principle and how it plays out with respect to group of companies is being managed when it comes to subsidiaries and holding or parent company. And that is why section 67.2 is actually crafted the way that it is. That because we know how do we get this holding and subsidiary company coming. As I told you, you may have like a company which probably, let's say that owns, let's give this example, a company which owns like a whole landed property, okay? Let's say it has like a factory, cement factory, and then the plants, the manufacturing plants and all that belongs to that company, let's say company A. But then it wants to spread its risk in a very clever way. So we decided to incorporate another company, company B, which will actually own trucks, right? Trucks for cutting the cement bags. Then he set up another company, which will actually hire, train, and manage, staff that will be working at the factory. So you look at it closely, you notice that all the various other companies, this company A has got significant interest, and the interest that it has is like it has either the totality of the shareholding or significant shareholding and so on. So that is what we mean by the group phenomenon. And when it happens that way, there could be an abuse as far as the capital maintenance doctrine is concerned. And that is why section 67.2 is sounding that caveat. We have also talked about stated capital. What is it? We've explained stated capital basically, but let's look at the statutory rendition of the components of stated capital. So section 68 gives us the various components of stated capital. And what are these? The stated capital of a company, according to section 68, consists of the sums of the following items, or aggregate of the following items. A, total proceeds of every issue of shares for cash, including the amounts paid on costs made on the shares issued, with an unpaid liability, less deductions for transactions costs that are direct and incidental to share issue. So Simply put, or the bottom line is that the first item is talking about monies the company has actually made from issuing shares. So that is what it's talking about. So you have taken care of maybe like brokerage, commission, and so on and so forth. So having taken care of all that, what is left as the money coming to the company by reason of the shares that it issued. So that is what the first item is talking about. Then the second item of stated capital, the total value of consideration, as stated in the agreement, received for every issue of shares otherwise than for cash. Remember that when we're discussing payment and issue of shares, we did make the point that although the preferred consideration for shares is cash, but it's not all the time that the company will be lucky to get cash. And sometimes it may be necessary for the company to enter into agreement to accept payment in kind, as it were. The only caveat we noted was that I think when within 28 days, we are supposed to go and deliver particulars information of such agreement, under which the company accepted payment, otherwise than for cash with the registrar of companies. So the money equivalent of that is also part of the stated capital. Then the third component of stated capital, the total amount which the company by special resolution resolves to transfer to stated capital from reserves as defined in section 70, including credit balance on the share deals account. So that is also part of the stated capital. So we are talking about another concept within here. So the third item, is saying that the company can pass a special resolution, right? You know, special resolution, shareholders have a meeting, notice is given ahead of time. We are going to pass a resolution to transfer money from the reserves to the stated capital. And at the meeting, they get 75% or 3/4 agreeing that yes, that should go ahead. So that's what we are talking about. So where you've gone through that procedure and the company actually has reserves, the money can be transferred from the reserves to the stated capital. Then the question which immediately will come up is this. When we say reserves, what do you mean by reserves? Well, if you talk about reserves, we are talking, and as I say, I put in a very simple way, that the money the company has made in excess of its stated capital, that is the reserves. In other words, if you aggregate all the monies of the company, having taken care of liabilities or the debts that the company owed, having paid all that, you've done the balance sheet. Now, you get more money, far greater than the stated capital. Now, the extra money, after taking care of the stated capital, the extra money left is what we call like the surplus, okay? And we are being told that the company can pass a resolution that money should be transferred from the surplus to augment the stated capital. But we are being told that in trying to work out the details of the components of stated capital, certain elements should be disregarded or should be taken out. So 68.3 is telling us, 68.2, let's start with 68.2, is telling us that paragraph A or B of subsection 1 does not require proceeds or value of the consideration received on the reissue of treasury shares to be added to stated capital. Can anybody explain why that is the law? That when we are trying to work out the details of the component of stated capital as in terms of monies which will be created from reissuing of treasury shares. We don't treat those monies as part of the stated capital. Can anybody explain why that is so? Is any hand up? Okay, let me explain. Now, if you remember, under 68, 1A, you talk about total proceeds of every issue of shares, every issue of shares. But with respect to 68, 2, when it talks about the fact that proceeds or monies from reissue of treasury shares should not be added, what it means is that the treasury shares have once been issued before. They were shares which were issued and they've been acquired by the company. So in terms of determining the stated capital, they have already been taken account of. They've already been taken account of. So where they are reissued, they are not supposed to be included again. And that is why we saw that if there should be a positive net balance, that is, if the reissued price is greater than the original price at which they were originally reissued, then that is the gain to the company. And that can be used for purposes of maybe funding other redemption or some other purchase, as we saw. So if you look at the subsection 3 in our discussion. But the other point to note is that the amount of stated capital is not cast in stone. It may be reduced by following strict procedures prescribed under section 69. We are going to look at it where the company will pass a resolution. You go to court for the court to confirm, and then the stated capital is reduced. And reducing the stated capital is really a big deal. And that is why the procedure is quite elaborate and also cumbersome. Because don't forget that stated capital refers to shareholders' money, right? The shareholders who actually make the company what it is. Their money is the stated capital. So if you are going to reduce the stated capital, it must be done cautiously. Otherwise, you are going to interfere with some other people's property rights. So let's keep that in mind. But of course, when it comes to managing minority rights, okay, in terms of with remedy against oppression, illegality, unfair prejudice, and all that, it may be necessary for the company to order what you call the buyout of the sentient shareholders and so on. So that one will be taken care of when we are discussing section 220 to section 226. And because the stated capital is so important, that is why section 68(5) says that within 28 days after the raising of a stated capital, the company shall deliver to the registrar for registration particulars in the prescribed form showing the amount of money so raised and the total stated capital, distinguishing between the amounts attributable to each of the items specified in subsection 1. In the past, when we used to have what we call the concept of minimum capital requirement, okay? When a company have been registered under the repeal at 179, apart from the certificate of incorporation, there was also what we call the certificate of commencement of business. Now that has been actually abolished now. But when that regime was in force, if we are company limited by shares, before you get your certificate of commencement of business, you need to demonstrate that you have satisfied the minimum capital requirement. Now, despite the fact that that has been abolished, we still have important rule 68.5, which tries to ensure that the company will make full disclosure regarding its stated capital at every point in time. And that is why 68.5 is saying that within 28 days, so 28 days after raising stated capital. And how is it stated capital raised? By issuing shares, the monies that we are making from cash or from non-cash equivalent. You are supposed to disclose that to the Registrar of Companies. Or if you have made transfer from surplus to augment the stated capital, you're also supposed to indicate that. And where you do not do what is expected, subsection C 68 permits the veil to be lifted and sanctions applied against the defaulting officers. In absence of question, we move on to reduction of stated capital. But because what we've done is so far, it's not difficult. It's just a little bit technical, but it's not difficult. We are going to pause here and then we'll continue our next class when we discuss the reduction of stated capital. And then we also discuss the rules on the distribution of dividends. And I think we should say goodbye to shares after that particular discussion. And we can start discussion of the lending, borrowing in the form of debentures. Yeah, so in absence of questions, have a good night.